pray that as we discuss, you will give us clarity. We thank you, and in Jesus' name we have prayed.
Thank you, my Lord, for that prayer. We are having a little bit of challenge for that online link. But the YouTube is on, so people can follow on using the YouTube as we fix the online link. And so without much ado, I'm going to invite Honorable Justice Charles Kasiba. I don't know, my Lord, if you're ready to do the presentation. I give you a few minutes, and then you can give your presentation. Then we will go into the plenary. Let's welcome him as he comes to make his presentation. My Lord, you're welcome.
I can start. In the interest of time, I think I can start my presentation. My Lord, the head of Family Division, your Lordships, your Worships, and all participants present. I'm going to quickly run through this paper. The overview of the Succession and Amendment Act 2022, why the expiration of letters of administration, stroke probate. Your Lordships and all the participants, the amendments of 2022 to the laws relating to succession were necessitated by many factors, among others, to accord equal rights to men and women, protect the rights of those occupying the principal and residential holdings, to increase the share of a surviving spouse in an estate in the instance of intestacy, provide for welfare of minor children and dependent adult children, to take into consideration and comply with the recent decisions of court, including the Constitutional Court, and generally to bring the law in line with the Constitution and other laws. As you are all aware, there was that decision which was made in 2007 in the case of law advocacy for women in Uganda versus Attorney General, where quite a number of the provisions in the Succession Act were declared unconstitutional. In fact, there was no law on intestacy since 2007 up to the period of 2022. So most of the sections were nullified, including section 27 that was providing for male intestate succession. It was therefore impossible to distribute the estate of a person who died without leaving a valid will, unless all the beneficiaries agreed or court made an order. Very many cases were in court, yet the courts did not have the law to guide them in their decisions. Thus, the necessity to amend the laws relating to succession to avoid and to fill the void and provide for other related matters. Now, I will quickly run through what changed in the law that commenced in 2022 on 31st May 2022. On the will part, the probate part, because this was formerly 100% discretionary on part of the testator, now there was some few points of checks. One, what constitutes a valid will? A valid will must be signed by the testator and attested by at least 2 witnesses, each of whom must have seen the testator sign or received a personal acknowledgement from the testator of his or her signature. It's now a requirement of law that the testator and the witnesses must sign on all pages of the will and include their addresses. So you'll refer to section 47 of the new Succession Act. And indeed, some of us who are there already practicing, we have seen where people have attempted to forge signatures. They vary substantially on each page. You can easily tell that this was not the same person signing. So that was one of the intentions, to put more safeguards on a document called a will, because it can dispose an estate of billions, even trillions in big economies. So there was a need to ensure that that document is given more protection under section 47. Restrictions on what can be disposed of in a will. So there was also check on the testator's discretion. The principal or other residential holdings of a testator shall not form part of the property to be disposed of in a will, except where the testator makes reasonable provision for the accommodation at the same station in life for the spouse and lineal descendants who occupy the principal and other residential holdings at the time of his or her death. Therefore, the testator can no longer have freedom to dispose of the residential holding in a will as it was before. He could give it to a friend, he could give it to a girlfriend, but now the law came in, unless you have made the same equal provision to maintain the person at the same station in life, the law prohibits the testator from bequeathing that property to other beneficiaries it is reserved for the spouse, making reasonable provision for maintenance of the spouse, children, and dependent relatives in a will. This was also made clear, and indeed aggrieved parties can come to court and seek this relief under Section 30, subsection 1 of the Succession Act. There was also the issue of who preference to administer an estate of an intestate. As you are aware, before, a spouse had a direct recourse to court without going through the Office of Administrator General, which of course it had some challenges, especially in Muslim marriages and polygamous marriages, who would come. Therefore, if there are 4 for Muslim arrangement, who would be granted? If one came to court, would she get? So now there was guidance on this, that the surviving spouse has preference over any other person in administration of the estate of the deceased intestate. See Section 199, subsection 1 of the Succession Act. So the spouse has a preference. However, the preference is given to the surviving spouse might be disregarded by court and or the Administrator General, where the surviving spouse is not a fit and proper person to administer the estate, or for other justifications. See Section 199, subsection 2. So the court has that discretion and the Administrator General to disregard a spouse if found unfit, and that is to the discretion of court on a number of reasons. Say she's a drunkard, she abandoned the home, and also where there are many arrangements of in Islamic marriages, if there are 4, the court can exercise discretion to add other people in the interest of justice. Now, the distribution of the intestate estate. So, in the case where there are dependent children or children who are below 25 years but are still going to school, before this estate is distributed, at least 20%. It depends on the on how many beneficiaries are below 25 and how big the estate is. 20% is the maximum. However, if the estate is very huge, you might even consider 0 point something. And if the child is 1 and is at the university at the age of 24, the administrator is allowed discretion to see what can be reserved. Otherwise, for the smaller estates, 20% can all be reserved for the welfare of children. And we thank Parliament because this was in accordance with the realities in our country, that children finish university at around the age of 23, 24, 25, not the 18 years as provided in the Constitution. So similarly, the principal residential holding and other residential holdings shall not be distributed but reserved for the surviving spouse and lineal descendants who were ordinarily residents therein at the time of the deceased's death. The rest of the estate is then distributed as follows. So those are the only allowable deductions before the estate is fully distributed. The residential holdings and the other 20% if the estate has children who are under that category of beneficiaries. And of course, when you reserve them 20% or less, or 2 or 3, does not mean that they are not entitled to a share in the rest of the estate. They are also equally entitled. Where there is a surviving spouse, children, dependent relatives, and customary heir or heiress, now the surviving spouse gets 20%. This was an increase from 15. Now it is 20%. The dependent relatives were reduced from 9 to 4%, and the lineal descendants, who are all the children of the deceased person, get 75%, and the customary heir, also heiress here, you will add it there, also can have 1%. Because also our sisters can now legally be customary heirs. Where there is no surviving spouse and dependent relative, but they are surviving lineal descendants, these lineal descendants are the biological children of the deceased, or the grandchildren descending. And here, heiress, wherever you see that word, you might take me to the Constitutional Court. Wherever you see it there, you substitute. The lineal descendants shall receive 99%, and the customary heir / heiress get 1%. Where the deceased is surviving only by the spouse, dependent relative, and customary heir / heiress, and no lineal descendants, the spouse will get 50%, the dependent relative 49%, customary heiress will get 1%. Where the deceased is survived only by the customary heir / heiress, and the spouse gets 99%, the customary heir / heiress gets 1%. Treatment. Where the deceased is survived by only a customary heiress, and there is no surviving spouse, lineal descendant, dependent relatives, the property is divided equally amongst the person's nearest relatives. That one now you have to, there is a tree there in the Succession Act that can help you guide who is the nearest. If they are direct grandchildren, those ones are nearest than great. So you have to trace that, starting from the parents. Treatment of the residential holdings, houses, that one I already talked about. The residential properties, these are the residential properties occupied by the deceased before or her death, are not distributed, but remain the property of the spouse. Children below 18 years, children above 18 years but below 25 years, if unmarried and still going to school, and lineal descendants with disabilities, physical or mental, who ordinarily were residents with the deceased at the time of his death. This actually means that a person can have a girlfriend who has children like in Waise, and he has an official wife in Kororo. When he dies, the other property in Waise remains for the what? For the children who are minors. So it will not be brought into distribution. It is it must be taxed off. So in this amendment, it looked at a wider picture than one individual residential holding, and the qualifying factors are children and the spouse. So that one have to put it into consideration. Before, that house in Waise would be brought into the estate for distribution. But now the law made it clear to protect those minors and spouses if the marriage had more than one partners. The effect of separation of the spouses under the law of succession. If the spouses were separated, not living together as members of the same household, the surviving spouse does not benefit from the estate of the deceased spouse except where the surviving spouse is on approved study leave in an education institution, where the deceased is the one who separated from the surviving spouse, or where the deceased is the one who caused the separation. So if you come up and slap your wife and she moves out and then God calls you immediately, that should not be a factor to disinherit you of your share. So now the law looks at an element of causation. Or if actually you move out yourself, these days men also know how to to go and get married elsewhere. They abandon the home and then he dies from somewhere, and then they say, no, at the time you were not living with your spouse, but who went away? So the law here came to the realities and say if the causation is on part of the deceased, then the spouse is not disturbed. She is entitled to her share in the estate. However, the surviving spouse may apply to court and obtain an order declaring that this provision on separation should not apply to him or her. This application must be made within 6 months after the death of the spouse. You can even enlarge time. So this one is where those who are the ones who fought, there has been something trading in the media today. So there you go and inquire into it. Somebody can come where facts are not clear. Somebody can come to court and say no, whereas we were in separation. This was the arrangement and these were the causes, and then court in its wisdom can declare that the person is entitled to share. Consent of the beneficiaries before disposal of property by administrators, executors. As a general rule, an administrator / an executor of an estate has no power to sell property of the deceased without the written consent of all the beneficiaries or their guardians in case of minors. See section 267 subsection 1. So this was also very good. Most of the cases, as the head of the family division and their lordships there, this was a very common thing. It had to be chewed, where the administrators thought the property belongs to them and they would dispose at their will. So now it is mandatory that you obtain consents of all the beneficiaries, and if their children are beneficiaries, you obtain them from their legal guardians, those who have obtained legal guardianship from court holding orders. And if it is unreasonable, then the administrator can come to court and say it is necessary that this property be disposed of for the following reasons, and court will inquire into it and can give an order directing that the administrator, executor, or executrix for that matter disposes the property. Validity of letters of administration. Probate letters of administration are valid for 2 years from the date of grant. See section 255 subsection 2 and 256 subsection 2 of the Succession Act. However, this might be extended for an additional 2 years or such other period as the court might determine. See section 255 subsection 3 and section 256 subsection 3. So the court looks at the challenges, maybe litigation, or how big the estate is, or compensation. It assesses. It can actually give 6 months, it can give 5 years, it can give 3 years, it can give 2, because here it is looking at the merits of the application. There has been issues of pension. Pension letters are exempt, but courts, banks and the Office of Titles do not recognize them. They think all letters expired. So sometimes some of us have been able to make some of those letters and say it is granted until pension what? Ceases. Because also pension depends, it is extended until pension ceases. My Lord, the head of family division, as this practice goes on, they will make more improvement and maybe say where an estate is receiving pension and their other properties, the other properties can have a separate grant that is limited to 2 years, but pension is given a limited grant for purposes of that pension, because the law allows a grant of limited grants limited to pension, because pension it depends. If the person never obtained anything, the estate can earn for 15 years as a maximum pensionable period. But that is for some future innovation. At the moment, it is a bit discretionary because banks keep on pushing the people saying this document expired. And when they come to court, you have to see what remedy is provided. The court, before extending the grant, must be satisfied that it is in the best interest of the beneficiaries and that the beneficiaries have consented, and that the administrator executor has complied with any conditions upon which the grant was issued by court. So, my Lord, the head of family division, Justice Keiterima, will come in and add more on that. You might not have 100% democracy anywhere. No, the representative of Administrator General is here. When they are issuing certificates of no objection, not everybody consents. Not everybody consents. So you have to gauge. Don't say because Parliament sometimes might not have the practical element of saying that every beneficiary should do what? Consent. So you look at the reasonableness of the administrator and who is objecting, and take the decision in the interest of the estate. Offenses under the new Succession Act. Offenses under the new Succession Act, there are quite a number. I will run quickly through them. Where a person who intermeddles with the estate of the deceased person. So if the offense of intermediating now has both imprisonment not exceeding 10 years or 20 million fine. So intermediating is when you use the property of the deceased property without letters of administration or the authority of court. But also there is a section which allows now people to lawfully intermeddle within 3 months. Before it was automatic. If a person has died, you were not supposed to do anything without the approval of Administrator General, as if people used to go to the Administrator General before they would bury. But now the law allowed them 3 months to make what they call intermediate expenditure of fees, of burial. The law saved them now that burden of 3 months. Any person who evicts or attempts to evict the beneficiary entitled to occupy residential holding, the fine is 3.360 million, 3,360,000, or imprisonment. So those children should not be evicted from their houses. If one attempts to evict the one of Wise, he will commit that offense. An executor or executrix who, before the grant of probate, misapplies the estate of the deceased person, subjects it to loss or damage, is guilty of an offense and is on conviction liable to imprisonment for a term of 2 years or a fine of 960,000 or both. Fine and prison term. See section 265, subsection 2. In addition to this penalty, the person convicted shall be liable to make good to the estate and the beneficiaries of the estate the loss or damage so occasioned. Where a grant of probate or letters of administration is revoked by court on grounds that it was obtained fraudulently or by concealing information from court, where it is revoked because the administrator or executor or executrix has mismanaged the estate, the executor, executrix, or the administrator shall once convicted be liable to imprisonment for a term not exceeding 3 years or to a fine not exceeding 1,440,000 or both prison time and fine. See section 230. An executor, executrix, or administrator who misapplies or misappropriates or cannot account for the proceeds accruing to the estate of the deceased person or to a beneficiary of the estate, or subjects the estate or a beneficiary to loss or damage, commits an offense and upon conviction faces imprisonment for a term not exceeding 3 years or a fine not exceeding 20 million thing, or both the term and the fine. See section 327 subsection 1. The court shall, in addition to those penalties, order the executor, executrix, or administrator to make good the loss or damage occasioned to the estate or the beneficiary. So these offenses, I think, our worship Katshabe time is still at our, okay. So a person who takes possession of property of a deceased person for more than 3 months without the authority, that's what I was trying to explain, without the authority of letters of administration or probate, or without the authority of the administrator general commits an offense and is liable on conviction to a fine not exceeding 20 million or imprisonment not exceeding 10 years, or both the fine and the prison term. This is in addition to making good any loss caused to the estate or beneficiaries. Section 265 subsection 8. A person who refuses or neglects to deliver any property to the Administrator General or his or her agent when called upon to do so, or lawfully takes possession of the estate property and fails or neglects to report to the Administrator General the particulars of the property and the steps taken to preserve such a property, commits an offense and is liable on conviction to imprisonment of 3 years and to a fine not exceeding 1,440,000, or both fine and prison term. Section 11, subsection 7 of the Administrator General's Act. A person who knowingly gives false information and makes false statements in the petition or declaration, which courts must be, of course, able to invoke these sections, because people don't declare some beneficiaries and declare the property. So this is one of the offenses created there, and the term is 7 years and a fine of 3.3, or both the prison term and the fine. See section 245 of the Succession Act. Also, the guardian, a guardian who misappropriates the property of a minor, commits an offense and is liable on conviction to imprisonment for a term not exceeding 5 years or a fine not exceeding 3.5. This is in addition to making good any loss caused to the minor under section 44, subsection 4 of the Succession Act. Where letters of administration or probate has been revoked by court, a person who willfully and without reasonable cause, where letters of administration or probate has been, some people use it as singular, others as plural, has been revoked by court, a person who willfully and without reasonable cause omits to deliver the revoked letters of probate or letters of administration to court that issued it, commits an offense and is liable on conviction to imprisonment of a term of 3 years or a fine not exceeding 1.40,000 shillings or both. It is very common that courts revoke letters or even call them in a very exceptional way in a citation, although it's not a very good remedy now in the High Court, but court can order that letters be deposited in court, not through citation. Citation was some procedure in the magistrate's court which would condemn a party and had. Somebody would complain on oath, and then letters should be deposited in court. No, that has been said in the appearance courts. They have said that's condemning the person and had. Although when we were amending these laws, we didn't remove it in the magistrate's court act, but court in its wisdom, upon hearing parties, can say deposit these letters as the case goes on trial. But most people have been omitting to do so. So now there is a section that criminalizes such a contemptuous action because somebody is in contempt of court. A person who acquires an interest of a beneficiary as payment of services, this is required to the lawyers, rendered to the beneficiary. A person who acquires an interest of a beneficiary as payment for services rendered to the beneficiary commits an offense and is liable on conviction to a fine not exceeding 2.4 million or imprisonment not exceeding 5 years or both. See sections 329. So lawyers have been sharing an estate and say this estate has 100 acres, my share is 30. So now it's an offense. You negotiate, they should negotiate their payment in accordance with the Advocates Act. Saving and transitional provision, section 337. So the distribution of the estate under the rules of the intestate succession and this act shall apply to the estate of the deceased person who died on or after 5th April 2007, where the estate of that deceased person is not distributed at the time of commencement of this act. So this is about the principle of retrospectiveness or not. So if a person died on that day, that is the date when the Constitutional Court nullified the provisions in the Succession Act. So that the commencement period is 5th April 2007 if the estate has remained undistributed. A grant of probate or letters of administration issued by a court of competent jurisdiction before the coming into force of this act shall remain valid for a period of 3 years. After coming into force of this act, court may extend the period. So you are aware, that's why this process started. These letters, except for Administrator General. Administrator General, my lord, was allowed 5 years. I think they are remaining with one. How many years are you remaining with? 1.5 years. But in the new law, they are also supposed to do 2 years. In the new act, any grant to the Administrator General is for 2 years, and no privilege. A grant of probate or letters of administration issued to the Administrator General before the coming into force of this shall remain valid for a period of 5 years. We have explained that. A will made before the coming into force of this act shall not be affected by the provisions that require the testator and witness to sign and provide for their address on each page. So if a will was made before 31st May 2022 and it has no people who signed on each page, it's a valid will. However, on its implementation, it must comply with the statutory requirements. It should not dispose a what? A residential holding. Because now the statutory law has come in place. It has for the statutory, so that can be taken off unless there is provision for maintenance of the spouse at a reasonable state. Maybe another thing I didn't put here is that also a spouse, a woman, a widow who remarries before the estate is distributed is entitled to her share of 20% at the time when the estate is being what? Distributed. So even if she's happily married elsewhere, she's allowed to come and collect her share. Although this thing is not pleasant even to church, I don't know why. Because the woman is taken to have worked, to have been there. Now, if this one has gone to meet the Creator, that does not stop her to go and enjoy her what? Rights elsewhere of marriage. But when you are distributing the estate, she should come back and take her 20% to wherever. Why the expiration of letters of administration? As we conclude, there was the need to limit the duration of administration of an estate so that an administrator, executor, his or her duties within the shortest period exercises his duties within the shortest period of possible, rather than holding on to the estate indefinitely. Thus, a validity period of letters of administration and the letters of probate was proposed to ensure that administrator, executrix completes administration during the validity period. Before you are aware, family division, you have seen cases where people were administering since 70s up to now, including the administrator general. Recently, I saw something about Nachiyenje, something of 1983, 95, and those are so many years. And there are multiple administrators come in. This one dies, the other one comes in, the administrator general comes in at some point. You are not able to vet the reliability. So there is a need, that's why there was a need, including the prominent estates, but I am aware now the Office of Administrator General has gotten away from all estates. They got away from Satito, Winyo, Bunyoro. They got out of Mutesa 2 as estate. Quite a number of those in administration in perpetuity, 50 years, 30 years. People become like owners of the estate, yet they are supposed to be trustees. So now they have only 2 years to finish. If they cannot finish, they come to court and say we are unable to finish. And indeed, it has now started doing a good miracles. People have gotten to the big bosses of called what? Administrators or administrators. But women were not so many. There were not so many women who were administering estates. I don't know why, my lord. The administratics and so whereas the law had given the widows automatic rate, the number was not that big. So it was also intended to protect the estates from abuse by imposing a duty of care on the administrator, executor to act within the statutory period, but in case of any unfinished business, they seek extension. And actually in court, my lord, they come and face each other. You have been there in the office of the as an administrator. Now the beneficiaries come and face you before a judicial officer and say you have not been able to do A, B, C, D. Only that the court has not invoked the punishments, those offenses that have been created. When we reach that level, I think it will also be very good. To encourage efficiency in estate administration, to act diligently, file inventories within 6 months. People were not filing them, dispute the estates and wind up estates within the time frame. Also, the oversight role, the deputy registrars, they are supposed to follow up. An expiration allows court to periodically review administration. So this is very, very good because they are able to see how is the estate. Because these administrators are actually agents of court, but they had been abandoned. Now the court can monitor, even the deputy registrar can occasionally call upon them. There is a provision, my lord, which has not been implemented of mediation, arbitration before the chief or the deputy registrar. I think you have to spearhead that, my lord. To ensure that on the renewal of letters of administration, letters of probate, the court considers each application on its own merits, and the period of extension is dependent on the needs of a particular estate. Here, the court now looks at it. It can even extend for 2 months, although it's very unreasonable. 6 months at least, for you to wind up the estate. So here, court is given all its role to determine the particular period to the unique, to the peculiar circumstances of an estate. I thank you for listening to me.
Thank you, my Lord. Let's appreciate His Lordship for that informative paper. We can as well jot down our questions, and then I ask Justice Kitirima to come and present. Then we have a joint discussion. I think his paper usually feeds into what he has said, so it's always good that we have the two papers, and then we have the plenary. So let's put our hands together and welcome Honorable Justice Kitirima, the head of the Family Division, to come and make his presentation on practical aspects of handling applications for renewal of letters of administration / probate, what to look out for. My Lord, you're welcome.
It's not a touch. Good afternoon, my lords and your worships. I'm used to a touch screen. This is not one. Letters of administration. Letters of administration. I think I'll request Patricia to come and assist as I start. My lords and your worships, you're welcome this afternoon to our review and the training. I do not want to call this a training. I think it will be more or less a discussion on how to handle these type of applications. As a result of the amendment of the Act, as a family division, and I am sure with all the circuits there was an avalanche of applications. I call it an avalanche because the number of registrations that came to the division were so many. I think it was unprecedented that as a division we're overwhelmed by what came in. And I want to take this opportunity to thank letters of administration, to thank the administration for the intervention, because when we were overwhelmed, we made a call, and that call was heeded. We have had a special session where 5 judges were involved, and they gave us a very big relief. I can see Dr. Ichokit here. I thought the others would also be here. Justice Emoko, Justice Jane Kavuma. They gave us a boost, and they were able to dispose of over 1,000 cases. Now, to use the language of the commercial court, because I see some judges from the commercial court who will be participating. When you are dealing with letters of administration, LOA, when you are dealing with a typical estate within this region, and I want to give a really bare minimum. Assuming you are dealing with a 3-bedroomed house on a 50 by 100 size plot, you are dealing with something whose unit cost is about 500 million shillings on the minimum, yes. You are dealing with something of about 500 million shillings as the bare minimum. So, if you are able to dispose, for example, 100 cases, that means you have unlocked, if again I should borrow the language of the commercial court, you'd have unlocked to the economy 50 billion shillings. Because this is an estate that was not available to the beneficiaries, but because of the grant or because of the letters of administration, you are able to avail this estate to the beneficiaries. You are able to avail this estate to the beneficiaries for them to transact, for them to be able to get fees for the beneficiaries, for them to be able to mortgage and get money for commercial transactions. So in the last session, if I say that about 1,000 cases, over 1,000 cases, actually there were about 1,400 there, of those cases were disposed of, you can see what was unlocked to the economy that people could now be able to deal with. I want to appreciate the presentation of Justice Kasibayo. He's actually responsible for this law. All these amendments you see, I want to believe he had the highest contribution, and that's why we use him as a resource person. There's the rationale to everything. But I think what it did, what this amendment did, was to awaken the sleeping administrators and executors who just went to their job most of the time and did not perform. It also gave an opportunity to the beneficiaries to make these administrators and executors account for their actions, because now you know after 2 years, you'll be held to account as an administrator if you have not accomplished your mission. So I appreciate that he has done justice to the substantive part of the law, and I will skip most of it. Only now to state there was a debate. Was it a renewal? Was it an extension? That debate was initially there. If the grant has expired for 2 months and an application comes in, would it still be an extension, or would it be a renewal? That debate was there for some time. But luckily for us, we were saved by the provisions of the Interpretation Act, Section 34, subsection 3, which provides that whereby any act, a time is prescribed for doing any act or taking any proceeding, and power is given to a court or other authority to extend that time. That power may be exercised by the court or other authority, although the application for the exercise of the power is not made until the expiration of the time prescribed. So it still remains an extension despite the expiry. Even if you make the application after 1 month or 2 months, the application is for extension, not for renewal. Yeah, at times you get those challenges from lawyers who want to challenge you. So I think the provisions of the law have been given. I will not go there. Let me go straight to the practice in the court. I must say it's a practice because we have not had regulations to the act yet. The amendment was there, but you know, with any act there must be regulations. But before the regulations come in, we've been proactive as a division on what we should do when implementing these amendments. So what to look out for as a trial judge? The application is usually by notice of motion arising of an administration cause. Therefore, you should be provided with an administration cause file. My lords, don't attempt to extend these grants without that original file. Why is that file important? You want to know, is this applicant actually the former administrator of this estate, or it's somebody different? So you'd want to look at the former grant and look at the applicant. Are they the same or are they different? Secondly, you want to look at the list of the beneficiaries. Over time, we discover that at times people just bring a list of beneficiaries and they just sign and they say they have consented to this application. So usually in the petition, when people are applying for the grant for letters of administration, they would have listed the beneficiaries. So, are these beneficiaries who have consented to this application the beneficiaries who were actually listed in the petition, or are they different people? How long has this administrator been administering this estate? Because that's important when you're extending time. The grant to some was given in 2010, in 2015. So usually the question you want to ask is, what is it you want to do that you never did in the last 10 years? You want to interrogate that person. And some of them are very honest. They will tell you, we didn't know what to do. We know that ignorance of the law is no defense, but in this case, I think we should be sympathetic. Many people never knew what to do. The presumption was that, you've become the next owner and you manage the estate on behalf of the deceased forever and ever. The other aspect you'll need to look at is that you may need to interrogate the beneficiaries before you. The simple question that usually comes, if you want to avoid forgeries, you pick up like one and say, okay, name the rest of your siblings. And you'll be surprised in some of these applications. People may not even mention one name when there's a list of 10. Then you say, but how can you fail to know your siblings? That is a red flag. Okay. Our practice has been, there are two ways of bringing these applications. To some, it's an expert application by the applicant, but with attached consent of the beneficiaries. But for us in the family division, we have said, if the beneficiaries are to be aware or to know what is happening, they should be made respondents to this application. Because at times this consent is obtained by false pretense. Some administrators, I'm told, they say, we are trying to pursue a compensation from government, so you just sign. And the beneficiary is in a hurry, just sign. So we said, for the beneficiaries to appreciate what is happening, let them be made respondents so that they are served with this application. And if they want to consent, they can then consent. But if they have reservations, then it's an opportunity for them to file an affidavit in reply objecting to the application. Are the reasons advanced for the extension valid? In most cases, they are not. Somebody has just sat on the estate. But in our view, if the beneficiaries have no problem with the extension, you can overlook that. Because as I've said, many of them never knew what to do. And the beneficiaries don't mind that this grant should be extended. So you can, because it's in the best interest of the beneficiaries, extend even if there is no valid reason. What properties are listed in the petition? Now that helps you to determine the duration of the extension. In the petition, one listed a 3-bedroomed house. Why would you give that person 2 years? What is he or she expected to do? On the other hand, if there are so many properties, most of them will come and say, we have been in courts. There are cases which have never been concluded. That's a valid reason for extending for maybe 2 years. But if there are very few properties, you want this administrator to account and hurry in winding up the estate. So you can say, okay, fine, you fail to file an inventory and fine account, I'm giving you 6 months to do both. Observe the physical status of the administrator who's applying for extension. Some of these people who will be coming before you are very elderly. And you wonder whether they actually have the capacity to administer or they are just acting as proxies. In that case, you have to interrogate the applicant and say, what capacity Do you think you still have the capacity, or do you need assistance? And there is no harm as a judge if the beneficiaries agree to add somebody to this grant, as long as there's consensus amongst the beneficiaries. Now, in applications which are contested, we have found out that at times the dispute is not that grave for you to hear the application and give a ruling, a detailed ruling. When you detect that there is a contest, we are privileged to have court-accredited mediators. You can send these parties and say, okay, I am sending you to an accredited mediator of the court. Go and have a discussion for 2 or 3 days, because you know your period is limited, and then get back to me. Surprisingly, they will come back with solutions. One may be insisting, you know, I want to also be added. The other time I was a minor, now I'm of age. You know, at times they want to know the formula of the distribution for them to consent. So once that is explained, they usually come back and consent, and then you give the extension. So mediation, for a very limited time, because of the duration of the session, could be of assistance. Now, when signing the grant for extension, ensure that the accurate information is captured, especially with regard to the time for the extension. Because of the nature of work, and at times the volumes of work, when these grants are being brought to you, you simply sign. You have granted 6 months, but the grant shows 2 years. So you should always look at the document and be sure that the time that is reflected in the grant is actually what you gave. Is one of the applications exempt by the law? The issues of pension you've had, those are exempt, but the banks have insisted. The banks have insisted they want to see these new grants, but I think we need to have a session with the banks and various institutions about this law. Because ideally, these people would not be coming to us for extensions. So the exemptions are in 2 areas. One, where pension is involved, and I think 2, where somebody is managing the estate on behalf of the minor. Now, that extension can go up to the time when this minor is of age. Those are the exemptions to the rule. As I've already stated, it's my considered view that if the beneficiaries want to add on some administrators or executors, that wish should be granted to ensure the smooth and peaceful administration of the estate. It may also apply in cases where the beneficiaries pray that the letters of administration or probate be revoked and granted to new executors or administrators. The argument here has been, in those circumstances, what do? Do you send the parties back to the Administrator General for a certificate of no objection? I think Section 230, subsection 5 of the Succession Act comes in handy. And it provides that the court may, on revocation of probate or letters of administration, grant probate or letters of administration to another person where the court determines that such a person is a fit and proper person to be granted probate or letters of administration under the Act. The discretion is given to the court once you determine that the person is fit and proper. How do you determine? The first criteria, if all the beneficiaries are in agreement, they trust that this person can manage, There and then you can determine that the person is a fit and proper person. And of course, other grounds. In some cases, it may be reported that the co-administrator is dead. Insist on seeing the death certificate. We have instances, we have cases of parties who apply for estates for people who are still alive. It could be the case here. They could just come and report also an affidavit that this other administrator passed on. Insist on seeing the death certificate. Otherwise, before you know it, the other one could emerge when they are declared dead. In my view, you should have a mentioned date in order to commit the advocates who may have scheduled other cases during the time the session is planned. It's also important to emphasize that the pleading should have been concluded, and you give timelines for concluding the pleadings, especially where the applications are contested. I don't know whether that time will be available for the mention of 300 cases, but if you want to commit the advocates especially, that would be ideal. Because you see, you are going to break up the time as I'm going to demonstrate. And it's important that the people are there. If you are going to handle a session of 300 cases, on average, in my view, you should be able to handle 30 cases per day. And I'm showing how that is possible by giving you this type ideal cause list. 9 from 9:15. It goes on up to 5. The previous session, some judges actually would go even up to 10 p.m. So, if you follow strictly these timelines, you are able to handle on average 26, but at times 30 cases. So that in the course of 2 weeks, you are done with all these applications. Now, we had a problem where parties will not appear. You've scheduled a matter, the party has not appeared on day 1. You've adjourned it to another day. The parties have not appeared. Some of those files were being brought back. I think you can dismiss. It's not a bar for the applicant to file for an application subsequently of a similar nature. So just have your output as a dismissal for non-attendance of the applicants, but don't reserve the file, because now you'd have brought back the backlog to the division. So, once you have mentioned these cases, agree on the timelines, be very strict, and the people will tend to follow when you are strict. And I've said, don't hesitate to dismiss if the parties have not shown up. Now, the other challenge, of course, is that this marathon may be bogged down by lengthy rulings. I would encourage you to use what we call extemporary rulings. Extempore rulings, this is a Latin word. Now, and I give you a typical one that I usually use. I've had the benefit of perusing the supportive affidavit and the written submissions to this application. I'm convinced that the applicants have demonstrated valid grounds for extending this grant. The beneficiaries of the estate have also consented to the extension of the grant as per their affidavits in reply, or consent attached, whatever applies. I will therefore grant this application by extending this grant for another year, or whatever other duration is considered, from the date hereof, to enable the applicant file an inventory and find account of the estate. And there I mention the name of the deceased. And that's my ruling, and I've concluded. But we have some people who reserve rulings in these type of applications for 3 months. You wonder what type of ruling they want to produce. Somebody wants a grant. I think that type of ruling is enough for the party to move on, because delaying for 3 months to write such a ruling could actually cost somebody's life. A child may not go to school because you have reserved a ruling for 3 months in that type of application. But most importantly, in a session where you have 300 cases, you really have to be brief. Now, on completion of every file, ensure that the file is taken for typing. These services are available so that the grant is signed there and then, and the parties move to their next destination. Because if you don't do that, it may cause the parties to keep on coming to court looking for this grant in vain. So it is possible that these grants can be typed and issued on that very day. The secretaries you find in the division are up to the task, and they can be able to issue these grants for you to sign. Because once the session is over, you wouldn't want to be disturbed by grants being taken to you for signing. So basically, that's how we have tried to manage this challenge. And I'm very grateful to your lordships for sparing time for us. I was joking with your lordships that they might have a culture shock by the type of clients they will encounter, but I'm sure they will be up to the task. So I thank you for listening to me. Where's the cover?
Let's appreciate His Lordship for that tips that. And so now we go in the plenary for both Justice Kasibayo and Justice Kitilima. Any questions, my lords and your worships, that you may have? We have somebody move around the microphone, and we can have an interaction or some questions that you'd want to ask before we go to the next session. My lords and your worships, any questions? Yes, is a question by her worship, Sarah.
Thank you so much, my lords. My name is Sarah Sime, former registrar in Church Family Division. In my work, I encountered a situation where there is an application for extension of letters of administration or probate, but when you check the original file, you find that there was an inventory, there was a final account, meaning that there is some property which was not disclosed either at the time of filing the original petition for grant of letters of administration or probate, and you find that they are in a fix. At the time of filing the inventory still, they will not disclose that particular property. Now they have a property which they want to carry out a transaction, and the Commissioner Lands has asked them for an inventory. which they have, but they cannot present. Why? Because that inventory does not disclose the property. So the documents we're looking for on the file, they are there, but they are not helping them. So how would you advise, my lords? I don't know whether I've been clear. Thank you.
The question is to
both their lordships,
Okay.
both the Justice Kasiba and Justice Kaitin.
Okay, thank you. There's a hand. Her lordship has a question.
Thank you. I missed Justice Kasiwayo's presentation, but at least I've heard part of Justice Kaitim's. Thank you. And I want to add on my voice to thank the judges who are coming in to offer some relief to us. But from the advice of Justice Kaitima, that you can have that timeline and you see how you can handle so many cases in a day. My experience for the last few days is that we have to be very careful when we are handling these applications for extension and leave to file the inventory out of time. It may not be as simple as we may think, because in this week alone, I've had 2 cases where I dismissed the application and I directed or advised the parties that you can go and file start the process from Luero where the estates were. But these are the scenarios. In one, the applicant had indicated there were 3 administrators, and only one was applying for extension. He attached the consent of the other 2, allowing him to pursue this case, and then also the consent of the beneficiaries. But when I looked at the consent, you could see that it's one handwriting. It was not a signature, but someone just writes like Margaret Mutonyi, Juma, just names. The handwriting was the same. I suspected something funny. So I looked at the original file, and in the original file, I was fortunate. I found the telephone contacts of the applicants, the co-administrators. When I called them that we expected you to be here, they said to do what? And I told them and said, we are not aware of anything and we have not given the consent to that person. In fact, our estate has a lot of problems. Then I told them, okay, now you're lucky. They have, the letter of administration has lapsed. You can now start the process afresh. Then I had one, actually this applicant who was pursuing disappeared, like, because I told him you can even be arrested for forging or uttering a false document that people have consented when actually there is nothing. Then one, the person died in 1970. They applied for letters in 2001, 30 years later. And in their description of in the petition, they just put, he left leasehold. They did not mention the particulars of this land. Then for 24 years and a half, since 2001, no inventory, no nothing. And then here he comes because the letters that were granted lapsed. So I asked him, what have you been doing all this time? He said, oh, we have been having wrangles. We have been in court. I said, have you been in court? He said, yes. Then I said, you should have attached evidence to show that you are doing something to this estate. But you have not attached any evidence that you are in court with the disputes, hassling over disputes. Nothing. So how can this court be convinced that you have done anything? So friends, I think the intention of this amendment was not just to rubber stamp extensions. You still have to take time to study the old file and then see whether this person deserves an extension or not. So in this particular one of 2001, I denied him because he has not exhibited that they were interested at all in this estate. A very confused person. I said, this estate has suffered since 1970 with no proper administration. So we need to be very careful. We may want to finish quickly and have the statistics, but we should know the intention of this. It is to make sure that the beneficiaries of estates don't suffer. Now, if we endorse people who have mismanaged the estate just because we have to extend them quickly, we might not be helping.
Thank you, my lord. Any other question? There's a hand the other side.
Thank you very much, Your Worship. My name is Samuel Munove. If it may please their lordships that have presented this afternoon, the first complication I face that I need guidance for goes to His Lordship, Keitirima. May it please you, Your Lordship, if you gave a practical reality or practical approach where an estate had a grant from a lower jurisdiction, but during the administration, there has been an enhancement of the estate properties. For instance, at the time of the grant, in, let's say, the Chief Magistrate's Court, the administratrixes did not discover the other properties. Now the grant has expired. How do they proceed? The second one goes to His Lordship Kasivayo. May you be kind and to me in particular to explain something about the succession register vis-a-vis the will in and the role of the Administrator General. Thank you.
Thank you, Your Worship. Yes, you can speak, then after His Worship will speak.
Thank you. Mine is on the period for, within which the grant for probate or administration, letters of administration, has been extended. These days, in these grants, we indicate the date when the grant will lapse. You have granted an extension of 2 years, and you indicate the date maybe from today, 28th November. Now, 2 years from today, it will lapse. But we tend to exclude the time between when the previous grant expired and when you are granting and when you are renewing it. I'm of the view that we be clear on this so that we don't leave out that period when the previous grant expired and when it is being renewed, so that the 2 years, for example, should run from retrospectively from the other time when the old grant expired, like 31st May, 2 years would expire 31st May of 2027. Thank you.
Okay. Yes, the next question.
Thank you so much. My name is Isaac Mpire, magistrate attached to the Chambers of Justice Samuel Emoko. I have one question to their lordships, and it's an inquiry. How would you deal with applications where applications for probate resealing, where the probate is still in force in countries that granted it? We had some scenarios like this when we're handling our session, and when people would go back to inquire, the courts would tell them the probate in our country is still operational. So how would we grant you another to be resealed here in Uganda? Yet the laws in Uganda under the Probate Resealing Act, in fact, would make that grant expire if the 2 years have already expired. So how would you handle such an application where in the other country that granted it, it's still operational, but here in Uganda, it has actually expired?
Yes, thank you. Yes, question.
Thank you so much. My name is Itogot Amy Amina. I'm a research magistrate attached to Honorable Justice Kahiji Patricia Simwe. Firstly, mine is a commendation to the family division. During the last session, the court adopted a lot of the virtual hearings. And for most of you who see on X and LinkedIn, most lawyers were applauding the court for that because most of our cases were on virtual hearing. So thank you so much for that. And then my second comment is, I also noticed that the virtual hearings in a way would cause a delay during the day, because you'd find that a family comes and they have you have a family of about maybe 40 beneficiaries. They don't disclose that probably 20 of them are not around. So the registrar calls the file, the judge is still waiting for cases. So if you start with such a file, you find that you take probably like maybe an hour or plus trying to reach the people, because this one is calling on the other phone, this one is calling on the other phone. Yeah, so my suggestion is to help the judges manage the time, because most families will, I notice they don't disclose. If you ask them, do you have some people online? They say no. Then when they enter, that's when they say, we have about 10. And then the judge has to keep noting, or the registrar has to keep noting. Sometimes they're using the same phone. So I was suggesting that maybe if there's a form where they can register and say we have about maybe 10 people online, so that it can allow the registrars to see how they align the cases for the day. It could help with hitting the target. Thank you.
Thank you. Should we say those are the questions and no more questions? Justice Kwizera, please, that's a question.
Thank you, my Lord, the head of the division and all facilitators for this important meeting. I have a few issues where we say if the estate involves minors, do you mean that we shall extend the letters of administration for as long as the minors are still minors until they become of age? So would I give an extension, for example, if the minors are 2 years and I'm looking at maybe the next 16 years, is it possible? Wouldn't we rather suggest that the administrator should devolve the minor's benefits into a guardian within the period that you would prescribe? I would need some light on that. Then Justice Kitirima talked about insisting on death certificates. Here in Kampala, anything is possible. A death certificate, a birth certificate can be picked from one of the streets here. So how are we going to ensure that that death certificate is not from Nasa Road? Last but not least, when Nakawa Circuit underwent closure and some of those files were transferred to different courts, some got misplaced. Even in archives here, you will find an original administrative cause file is missing, but an administrator has been holding on to his letter of administration. At times, they don't even care, keeping the rest of the petition and other things as long as they have the letter of administration. So in case such a person comes who has been administering this estate for the last 20 years, and we can't get this file, how are we going to help this applicant? Thank you.
Thank you, my lord. Justice Sabinyo here at the front.
Moderator, my question relates to the death certificates. I'm just building up on what Justice Kwizera asked. I had a matter where 2 death certificates were adduced in evidence. The applicant adduced a short death certificate and the respondent adduced a certified death certificate issued by NERA. And interestingly, the place of death and the date of death were different in both death certificates. I would seek your indulgence in such a scenario.
Thank you. Yes, my lord, then you can ask.
Thank you very much, my lords. My question is to Justice Kitirima. I just wanted to your practical approach on identification of beneficiaries. Do you have to insist all the time on the birth certificates from NERA? In the absence of that, if you're faced with a scenario where you're not able to verify or you do not have that certificate from NERA, what other approaches have you used or you recommend as a division? Thank you.
Thank you. My lord, let me add a few questions from our online audience, and then I invite you to respond. Sorry. So there is they say this is a comment. It's a comment saying that courts should develop a culture of issuing grants for effects unadministered. The practice of renewing or extending grant of administration for full term as if the estate has never been administered should be looked into. There are many types of grants in the Succession Act that our courts are not issuing because if an estate has been partially administered, issue a grant only to the remaining part. Somebody's asking, if an estate has been administered, why not issue a grant to the estate that has partially been not administered? And then another one is, what should be the course of action where administrators who filed a case in court as administrators of an estate now have expired letters? Is their case still ongoing in court? Should the administrators apply for an extension of their letters, or should the court maintain expired letters? I think this question also featured in the last meeting very prominently. What happens to people who have cases in court whose letters expired? Okay, then the other one is, what do you do in circumstances where an administrator is being sued based on letters of administration that have expired? Somebody is trying to find out how they can get off the hook. What is the likely remedy where the first administrator had subdivided the land and titles appear in their names? Do they remain administrators? This is also a very common question. Why are legal spouses required to obtain a certificate of no objection from the Administrator General, contrary to the law? I think Justice Kasiba, you should answer that question. I think like 3 people have asked that questions. There's another one also has asked widowers surviving all the time. The judge is asking that they should give a certificate of no objection before they are identified. In the event that 2 administrators have a dispute arising from mishandling of an estate property by one of them and the letters expire, can the innocent apply for letters alone? I think those are the questions, and at this point I want us to wait maybe for 5 minutes for the principal judge to make her way, and then afterwards we can have my lords come back here and do the plenary. Then we have the last 2 items and close. I'm told she's almost here. Any other question? I hope that is it for online. There's also another question of if the letters are lost. My lords and your worships, let's stand and welcome the Honorable Principal Judge. My lord, you're welcome from your long journey. We thank God for the safe journey. Thank you. We can have our seats. My Lord, the Honorable Principal Judge, my Lord, the Head of the Family Division, and Mr. Henry Kolova, representing the Administrator General. We want to thank you, my Lord, for joining us at this hour. And before you came, we had handled 2 presentations of the training on our program, which is the overview of the Succession Amendment Act 2022, why the expiration of the letters of administration by Honorable Justice Charles Kasibayo. We've also listened to Honorable Justice Eldis Kitirima on the practical steps of handling applications for letters of administration, stroke probate, what to look out for. And now, my Lord, you found us when we are in the plenary. We're done with the questions, and their lordships were supposed to be coming back here to respond to the questions, and then we can proceed. But my Lord, before we proceed, I would want to introduce the judges and the people that are before you, before I can call back their lordships to come. My Lord, seated next to you is Honorable Justice Eldis Kitirima, the Head of the Family Division. My Lord, you're welcome. And then seated next to you on the other side is Mr. Henry Kurova, the Assistant Administrator, representing the Administrator General. My Lord, with us, we have Honorable Justice Margaret Mutonyi from the Family Division. My Lord, you're welcome. We also have Honorable Justice Immaculate Businje, the Deputy Head of the Family Division. I think she stepped out. She was here. My Lord, we have Honorable Lady Justice Susan Abinyo, Deputy Head High Court Commercial Division. My Lord, we have Honorable Justice Vincent Wagona, Resident Judge for Poto High Court Circuit. He'll be participating in the coming sessions. Also, Justice Abinyo will be participating in the sessions that are beginning. I think after now, they are supposed to be beginning. They've been commissioned to start after the training. My Lord, we have Honorable Justice Alice Komuhanje, Judge, International Crimes Division, and also circuiting at the Family Division. My Lord, we also have Honorable Lady Justice Naga Wasilia, Judge, High Court Family Division. My Lord, we have Honorable Justice Kwizera Amos, Resident Judge, Bushenyi High Court Circuit. He will be participating in the coming sessions. My Lord, we have Honorable Lady Justice Wagumia Tumsime Patience, Judge of the High Court, Judge of the Commercial Division. He will be participating in the upcoming sessions. My Lord, we have Honorable Justice Charles Kasibayo, Resident Judge, Mbale High Court Circuit, our trainer. And the rest of the judges are online. We have registrars and magistrates participating in this training. My Lord, that's the far we had gone. I now would like to invite Justice Kasibayo to respond to some of the questions, and then afterwards, His Lordship Kitirima will also respond to some of the questions. I think, my Lord, you can respond from there, the questions. No problem.
Thank you. The first question was from Her Worship Sarah about an estate where an inventory was filed and subsequently a final accounts. In law, of course, that estate has been fully administered. However, that does not stop family members from discovering more properties, or even the estate subsequently receiving compensation. So there are 2 approaches, but the most practical one is an application for what the person online has commented about, what they call effects unadministered. You can actually come and have a new grant for that subsequent property that has been discovered for a new letter of administration called estate effects unadministered. if a final account was filed and not a partial accountability. The second question from Munove was about succession registers. Of course, as you are aware, there was a committee that was constituted, chaired by the High Court Judge, Kazari Oliver, then Musa Sekana and Ketra Katunguka, myself then as the Administrator General, the representatives of the Attorney General, and Uganda, and all other stakeholders, which made a finding that these estates were administered under the 1912 succession law, and therefore they are not subject to letters of administration. His Worship Munove also asked about the role of Administrator General. Yes, the Administrator General still holds these registers as points of references. The court, of course, litigation in these matters has not ended, can make inquiry and obtain information from the Office of Administrator General, which received these registers in 1967 under statutory instrument number 150. However, this matter is still pending in the Constitutional Court, whether or not letters of administration can be issued to the estates of deceased persons which were administered under the 1912 succession to land in Uganda up to 1967. So we shall wait the position from the Constitutional Court. However, the position as it was then was that these estates are not subject to letters of administration, and the then principal judge communicated to all High Court divisions and circuits to that effect. About the non-consideration of the elapsed period when letters have expired and when they have been renewed, I think you cannot validate a vacuum. If letters of administration expired and it took 6 months to be validated, you cannot put into consideration of the period of a lacuna, a vacuum, because in that period the administrators don't have any legal authority of court to make any transaction on behalf of the estate. On the issue of probate resealing, there is a recent Court of Appeal decision which simplified it, that the courts have no input. Once an application for probate resealing is made, the judge should reseal the probate from the Commonwealth jurisdictions. However, which of course now extend to Rwanda, Burundi. However, as the head of the family division is aware, you can't easily validate these grants in light of the rampant fraud in our country. On this issue, when you read it, because now the question was particularly targeting its validation or extension, if in their country, say Kenya, there is no expiry. But when you read these letters of administration, even from other jurisdictions, you will be able to find something with expiry. Even in our old laws, in our Succession Act before amendment, actually the period was even 1 year, my lord, the head of family division, was 1 year. The parliament gave 2 to be very certain that you complete your roles, that the final account was supposed to be filed within 1 year or other period as the or further period as the court may appoint. So when you read the grant from the country where they are coming from, you can be able to decide the period as provided, because these formats of letters of administration were actually inherited. We didn't originate anything. We have just started now, my lord, by putting these letters will expire but all that language was imported. So you can subject it to our verification, advertisement, and then decide to extend it depending on what fraud you are reading or not, and what period it can grant, and what property is it targeting in Uganda. It's not a matter of coming here and say, I am receiving this probate. They should be a property in Uganda, which you even declared in the other country that this receiving is targeting. For the issue of minors, I think there is a provision, my lord, about one minor or a legatee where that exception is. But for other minors, you see the estates in Uganda are mixed up. You'll find a 2-year-old whose brother is Charles Kasibai. They are all subject to the same laws. So there is also a provision somewhere where it allows, especially this reservation of 20%, a creation of a trustee. So these properties can be distributed to the guardians who have obtained guardian orders from court to hold them on behalf of the minors and the estate, and the letters expire. But unless, I think the exception was provided for one minor whose estate is being administered by a guardian. But where there are many minors, the law considers expiration, and property should be held by the guardians, who should account to court from time to time. The death certificate, of course, that's a question of forgery. NIRA is now our authority over them. They can even give you more tips to verify forgeries, but it's a common thing of forgeries. Online, they talked about effects unadministered. I agree with them, and I've given the example of Sarah's question of unadministered effects. And my lord, as we were discussing in my presentation, we can also look at limited grants. We should popularize them. If, for example, people are fighting these polygamous marriages, one is in Mbarara and another one is in Bushenyi. The one of Mbarara has never visited the Bushenyi land, and they are agreeing that the other ones of Bushenyi can take that property, and these ones take the one of Mbarara. You can actually give 2 grants. One limited to the property in Mbarara with its own administrators or administratives, and the one in Mbarara also with a different administrator. Still the same issue for pension, my lord. As we go on, I think pension should also have a limited grant which does not expire until the pension has ceased. Of course, no action can be maintained against an administrator of an estate whose letters have expired, unless if that action is by a beneficiary to the estate, issuing the administrator for maladministration or mismanagement. The action survives even when your letters have expired. But if it's a different party, a third party showing the estate, then the action abates. You may have to, the plaintiff has to move court, and I think, I don't know now, I think now it is 218, it's usually, it was formerly 222 for purposes of the suit, for the purposes of the case. So there should be another application to have that person come in to defend, if is not an administrator where the action is against that administrator for mismanagement of the estate. On the issue of divided land, it depends. These administrators, when they divide the land, they can hold it as administrators, or they can put it in their names as proprietors of the estate. So it depends. The questionnaire did not disclose, are they registered as administrators or proprietors? If they are registered as proprietors, it means the property has now moved into ownership, not in trust. Widows getting certificates of no objection. Yes, I agree that the law previously exempted them, but after practical experiences, there were questions, as I explained, of Islamic marriages where 4 widows are allowed. So the question therefore was, if one of them comes, can you give a no objection, or you have to sit all of them, the 4? 2, polygamous marriages where a person can marry even up to 100 sisters of ours, because the customary marriages law does not limit the number. So if you had to pick one of the administrators, who would be? And then also from the practical experiences is that I don't know whether it's modern middle income or what. There are several marriages which have children outside the wedlock, quite a number. And in most cases, the people who have died would not have disclosed to their loved ones that they have this number of children outside the wedlock. Actually, my lord, you would be surprised that the widow is meeting them for the first time in the office of Administrator General. And the number is like 10, 15, 7 from former house helpers. So how do you expect this widow to go and cater for their interest? She doesn't want even to see them. So that's why there was consideration that the Administrator General or court looks at dispensing in very exceptional circumstances, because the general rule also under section 199 is that administration preference is to the surviving spouse, but the Administrator General or court can dispense with them if found unfit. I think that's the rationale why now the court and Administrator General has to look at the suitability of a spouse. I thank you.
I think Justice Kasiba has answered most of the question. I just wanted to emphasize the issue that was raised by Justice Kwizera. If you look at the exceptions under 255.2, it provides that subsection 2 and 3 shall not apply to letters of administration granted under section 212. Now, those letters granted under section 212 are where the child is a beneficiary and a guardian has been appointed. In that case, you may extend the letters up to the age, to the point when the child is of age. And of course, the obvious one under section 4B is pension forming part of the estate. And also, you also have to determine when the pension will cease to be paid. So you cannot give a blanket grant, very open. I think you should be able to determine when that can be. In the case of a child, if you think she will attain the age of majority, maybe in the next 5 or 6 years, you can extend up to that period. Now, certificates from NIRA, we have the capacity now to detect in the division forgeries. So if we shall ask the systems administrator of the division to assist you on how to detect this, because we are now linked to them and we can be able to determine whether the certificates are genuine or they are not genuine. But the systems administrator could also be handy If you have some on file, they could always give a report that they are genuine or they are not genuine. As to whether you can identify the beneficiaries, some of these people don't have birth certificates. The nature of our clients at times do not acquire these things at birth. So it would be very unreasonable on the side of a judicial officer to insist on this. The trick is, as I've said, look at the petition. Was this beneficiary mentioned? If they are of age now, they should be having an identity card. You could ask for the identity card. The other trick, as I've said, is that you can casually pick on one and say, name the rest of your siblings. And you see whether they can do that. So there are other methods really as to how you can determine, instead of insisting on some of these papers that some of our people may not attain because of the nature of their background. Now to Justice Mutonyi, of course, an administrator has not been doing his job for the last 10 years. And you say, no, you have not done your job for the last 10 years. You go back, the application has been dismissed. So what have you in essence done to the estate? What is the way forward? That's where I am saying that because honestly speaking, some of these people did not know what to do. They did not know what to do. And therefore failed in their statutory obligation. So if there is no problem from the beneficiaries, if they are saying, well, our uncle could have not taken action for the last 10 years, but we still have trust in him to do the needful. He's the only person who can bring us together. He's the only person who can distribute the estate to us. I think some of these strict guidelines can be ignored for the sake, because the important thing is that the extension should be for the benefit of the beneficiaries. Once you establish that, the rest is secondary. Okay? So for me, as long as really the beneficiaries are saying this is the person that can do the job, I'll extend the grant. I'll educate the administrator on what he or she was supposed to do, and then I will say, okay, just do your work within 1 year. Okay? As long as I've said the beneficiaries are content with that. Inventory, you have found an inventory and a final account on the file, but still these people are coming for an extension. You know, discoveries are still made in these estates, including discovering beneficiaries, by the way. After 5 years, a beneficiary can emerge. So what do you do? For the purposes, I have seen situations where the beneficiary says, at least I want to be on record. I may not, the estate could have been distributed, but I want to be on record as being the child of the deceased. It gives me satisfaction. So in those circumstances, yes. But if the inventory and final account are on record and shows that the estate was wholly distributed, then there's nothing else to extend, unless you have discovered more things on the other items in the estate. I work with the judges in the division. They could wish to also have their input. I know I may not have exhaustively answered most of the question. Maybe I would give an opportunity to them to answer some of the questions. Virtual hearings, you only have to arrange with the systems administrator. Give notice. Because first of all, we have limited facilities. And therefore, if you are going to do a virtual hearing, you need to give notice to our systems administrator to provide the link. And that may not be possible within that day. So ideally, maybe 2 days or 3 days notice. But that is possible.
My Lord, just to make a correction, I meant where the applicant is forging the consent from the beneficiaries. surely once it is established that that applicant wants to continue the status quo and yet he has been doing a disservice, that such a person does not qualify to be given the extension, because it would really defeat the purpose of this amendment, because it was intended to stop people from managing the estates in perpetuity. What has been happening, because we are now having cases of 1996, 2000, they are still there, there are same people coming. So once it is established that they have been doing something, maybe they were just ignorant of the law, it is different. But where he's even lying about the consent of the beneficiaries, that's what I'm saying. We need to be careful. Some of these people can even parade someone who is not even a beneficiary, because it is a requirement that we must consult the beneficiaries, because we don't know them. But once it is discovered that they are lying about something, then they should not be given.
Thank you so much. And I wanted to also emphasize, as the head of the division has indicated, I think the trick is on the file, the administration cause. That is where the trick is, and it makes everything easier. As long as you're able to tell from the petition, these were the beneficiaries, then you're looking at the application and you're wondering, are they the respondents? Are they the named respondents? And then what is the property that is indicated in the petition? So that one makes everything easier. You're able to tell that the right people are before you. And it takes a short time to do that. But I also wanted to propose that we need to have a mediator mindset, even as we deal with these kinds of applications, that even when there is a contest, you may not even need to send them to the mediator. You can give them some leads on how they can come to reconcile. And you will realize that having understood, then they actually agree with, even before you, without you sending them to the mediator. I recently had one where I had two co-wives, now widows, and the application before me was actually not even for extension. They said that I should give them an order referring them back to the Administrator General so that they could get a certificate of no objection, because they wanted different administrators from the widows. But now the widows are the administrators, but they are disagreeing on how to manage. And the issue was actually on distribution. So I said, can't we agree on distribution? And just there was an agreement. So if we also engage that mindset of being mediators, but not going into deep into the issues, I think we can still expeditiously resolve these issues. But there is fraud, but the main file, the original file, is where the secret is. Thank you.
Thank you, my lord. Mine are just comments in relation to the questions that came, especially regarding, let me start with the first one, forged death certificates, where you are, the applicants are saying one of the administrators died and should be removed from the letters, and you extend for the you can quickly, those who do not have these applications on their phones, just have a QR and barcode scanner on your phone. The moment you scan that barcode, NIRA gives you instant information there and then. And that one is applicable to the certificates that were issued from 2021 and thereafter. For those ones below, you still go to the NIRA website and you say you want to verify a death certificate or a birth certificate. You put in the information given and NIRA instantly gives you an answer. It says, this document was issued by our office and it even brings an automatic stamp showing the registration number, the application number, the details of the person, and all that. I think this one, we shall have a practical session in the boardroom, such that for those who are unable to do it directly, we show you exactly how to do it from the family division. Then number two, for the applications where you'll be having advocates, and you are, because sometimes our process servers and the clerks might not easily get directed to them, this one, I think we shall also arrange a meeting for you, my lords, in the boardroom. And the judiciary website has been enhanced. Now when a practicing certificate is issued, everything is provided on the judiciary website. It shows the name of the advocate, the certificate number for that year, the address, physical address where the law firm is, the email address, and the mobile telephone contact, and the office telephone contact. All that is on the judicial website. We shall be able to show you everything. Then for the virtual hearings, it's important that when the process servers or the clerks are getting in contact with these people, at least we need to be given about 2 days in order to arrange with the systems administrator, because the licenses that we have for Zoom links are only 4, and you are coming 5, and you may find that all of you would like to be virtually hearing at a specific time. So it's important that the letters come in at least 2 days in advance, such that we do not put you at the same time. If this one has a virtual hearing at 11, all of you cannot have the virtual hearing starting at 11 a.m. So that's why that advance notice is very crucial. Then I have also noted that there are some of the judges who are coming and they've not been in ECMIS courts. My lords, I think it's important that we arrange a time and we give you a quick training on how the system works, because it's important for you to be able to track how much work has been allocated to you, how much work you've done, and how much work is pending before you. At times we are human, we might err, you might sign a grant and it's not uploaded, because as you will see, the work would be a lot. So you give it to a secretary or the systems administrator, they are running from chamber to chamber. So you have given them 10 grants, maybe the 9th has not been uploaded in the system. So it's important that we acquaint ourselves with the system. We shall see how to do that. And the systems administrator will be there full time to assist you in all ways. Then for national IDs, especially for the applicants and the grants, the beneficiaries who are the respondents, you will come across some people who will come with these letters from NERA saying that either the ID got lost and they have a letter from the ED. That one, we shall also handle it as we are looking at NERA website generally for purposes of verification, because it will be having a tracking number, and that one will also be able to help you as to whether this letter is from NASA Road or it was issued by NERA. Thank you.
Thank you, my lord. I would like to speak to dismissals because of the numbers that are expected of the session judges. In as much as dismissals are welcome, as a division, we discourage them, because it's very easy for a trial judge to have even 100 dismissals for non-attendance. So where does that lead us of the 300? We have a reserve. We have a huge backup that when you realize that not all of them are there, we always have a reserve for you. So you could have 300 or 350 and you pick from that. Also, like Justice Ketima mentioned, if you don't have the mother file, please do not attempt to have this matter heard, because the devil is in the detail and it is in the mother file. So the mother file is your password. And that is why it will always take you back to, if you don't have the mother file, you don't attempt, but you can ask for others. You could have on your list maybe 100 or 50 where the mother files are not readily available. So as a division, we are able to pick from the reserve and give you those that have. It could happen. So I know you're asking yourself, then why give us those files without mother files? And yet at the same time, first in, first out. So we have reserved those files for you, and the reserve is also readily available anytime. So I kindly advise you not to over dismiss, because it's the same thing as reinstating. And we are not, the numbers will always come back. Thank you.
Just the last one. When we are recording these proceedings, it's important to take as much information as you can. You may find somebody applied for a national ID while they are here at Plot 2 City Square, but right now where they are living is a different place. So it's important to get those details from the village level up to the district level and the telephone contact. And if possible, what they are doing at that time, such that you are able to locate them in case of anything. You might even want to ask a simple question and they've already left court. Thank you.
Thank you, my lords. Let's appreciate their lordships for the guidance. And I can see that their lordships who are going to visit, they are going to have a lot of support. We have a request. If you're the driver of UBL 268N, kindly make your way. The aerobics are waiting because your vehicle is parked in the area where they are going to have aerobics. UBL 268N, kindly go and move your vehicle to another place. Thank you. Yes, and my lord, also amidst us was Honorable Lady Justice Dr. Okello Echit Christine. She's here with us at the front. So now, without much ado, I would like to invite the representative.
My lord, I represent the Administrator General, who sends his apologies for not attending this session because he lost somebody yesterday, which I'm going to relay to this gathering. I wish to thank the pre-session meeting highlighted the unprecedented surge of applications for extension of time to file inventories, final accounts, and extension of probate and letters of administration. I take this opportunity to thank the Family Division for holding a successful court session dedicated to fast-tracking applications for letters of administration for filing inventories and extension of probate and letters of administration. The Administrator General's office was a beneficiary of this special court session, which was a great success. It is my humble request that more of these sessions be held by all courts, especially given the fact that the Administrator General's grants are due to expire in May 2027. I also want to sincerely thank the head of the Family Division for including the Administrator General in the division's weekly judicial officers' meetings, where matters of mutual interest are discussed. Regarding the issue of administrators' ignorance of their legal obligation, the Administrator General is emphasizing and educating intending administrators during family meetings about their duties and obligations under the law. We believe that such education and sensitization at the initial stage of the administration process will ensure compliance with the law and ultimately reduce case backlog. On the issue of succession registers, Constitutional Petition number 84 of 2023 still remains undetermined. However, beneficiaries of these estates are seeking remedies from the High Court under its inherent powers. For example, in the recent case of Damulira Ladisrao versus Commissioner Land Registration, miscellaneous cause number 7 of 2022, the court invoked its inherent jurisdiction to enforce a beneficiary's entitlement under the succession registers, which are in the custody of the Administrator General. Notwithstanding these judicial interventions, there is still a pending constitutional petition that is challenging or seeks to determine the powers of Administrator General in estates of deceased Baganda who died between 1912 to 1967. In conclusion, we are once again grateful for this opportunity to interface with the judiciary because the work of the Administrator General and that of the courts is closely interlinked. I again reiterate my previous plea to develop an interlinked online system between the Administrator General and the judiciary to facilitate the sharing of crucial information to curb fraud and ease service delivery to the general public. Thank you for listening.
Thank you so much for those remarks. We are coming to the close. My Lord, we will have Justice Kitirima come to invite you to close this session. He will give you a little bit of a brief of what happened in the last sessions, my Lord. Then we will have a group photograph, and then we'll have a cup of tea. Please don't leave our tea behind. But I want to thank you for being patient. My Lord, Honorable Justice Kitirima, you're welcome to give a brief, and then after invite the Honorable Principal Judge to close this review meeting. Thank you.
Thank you very much. My Lord, the Principal Judge, my Lords, your worships, I want to take this opportunity to welcome the Principal Judge to the Family Division. This has been an extension of the Family Division, and being your maiden visit, we welcome you most heartily. We want to, on behalf of the Family Division, thank the administration for the support they have extended to the Family Division. When this amendment came, as you have heard, there was an avalanche of applications and we were overwhelmed. So we made a call to the administration and they came in handy to support the sessions. And I can predict that we shall continue knocking on your door, my Lord Principal Judge, because these applications are still coming and there are very many. Just to give a brief of what this intervention did to the division. The 5 judges that came in a spell of 3 weeks, they were able to dispose of over 1,433 cases. Justice Joyce Kavuma was able to dispose of 320. Justice Kazare was able to dispose of 257. Justice Patricia Kahiji was able to dispose of 285. Justice Mokol, 256. And Justice Dr. Echokit Christine, 315. These figures may not be that accurate, but that is the range at least. Now, I had given an example of what it means to dispose a matter in the Family Division. The average unit cost of an estate in Kampala here, and we are giving it the very bare minimum. If you are talking about a house, a 3-bedroom house on a 50 by 100 plot, without any other property, the unit cost we are giving it 500 million. So every disposal you are unlocking, because this estate is closed to the beneficiaries, you are unlocking over 500 million shillings. So when I was making a quick calculation, this output actually unlocked, if we are going to use the bare minimum, unlocked 716 billion shillings, which would have otherwise been locked if these applications were not handled. So you can, that is the magnitude of the output and what the impact it has even on the economy. So we would want to thank the administration, and my Lord, we shall keep knocking on the door. The good news is that we are having judges who are coming, I think, starting next week, and I want to thank their lordships because they are very busy where they are. But we appealed to them and said, you have a social responsibility as a judge to help the most vulnerable people in society, and they accepted our call, and they have come in to assist. I also want to take this opportunity to thank their lordships in the family division for the hard work they put in, and to encourage them to continue. My Lord, work in the family division needs a lot of patience, needs a lot of empathy, sympathy. You are dealing with people who come to you and cry all the day. The nature of our cases, you can imagine somebody having wealth. There's money on the account, the child cannot go to school, he's just waiting for an extension of a grant of letters to access the money on the account. And they are not getting a hearing date soon. And many other things. Or they have a patient, they need to fly them to India, the estate is there, can provide the means, but because of lack of the letters, they cannot access those resources. So I want to appreciate their lordships and their worships for the effort they put in, and to encourage them to continue with that attitude. But most importantly, and I think at a policy level, my Lord, in top management, there's something I think we need to discuss. There are programs in government, wealth creation. It's a very prominent program in the government. But how about wealth sustainability? When this wealth is transferred from A to B, how do we sustain that wealth? Because the examples are many. Usually when the deceased passes on, you find the beneficiary is just selling off. And before you know it, the family that was rich a year ago is now in poverty. I think we need to have a program, and where I think the Administrator General's office and us and the government can support each other, is to try to educate how this wealth can be sustained. You've got this, you've got this inheritance. Formerly you were very poor, but all of a sudden you have landed into billions. How do you deal with that, with that miracle? It is something to think about. With those few remarks, my Lord, I now want to take this opportunity to invite you to address us. Thank you very much.
Good evening. I want to start by apologizing. I underestimated the distance, and then the fact that children are getting holidays today. So I am extremely, extremely sorry for keeping you waiting. But I was also when Justice Celia was talking about no dismissals, I saw Justice Wagoner's face falling. I think he was thinking, have I really made the right decision to come and be in the second special session? My lords, your worships, Administrator General, I see my sister Rachel there, yes, technical advisor, members of the bar, if any. I am honored to be here. This afternoon, I was supposed to be here this early afternoon, but I am still happy that I was able to get the last bit. There are two closely linked purposes here today. The first was the review, performance and lessons learned from the first quarter. I'm sure you have shared, and I've had a lot of it from the judges of the division about the hearing and disposing of the extensive number of applications for the extension and renewal of letters of administration, which were at the family division. And secondly, the training that has happened and orienting the honorable judges will be taking up the mantle for the second session to further reduce these numbers. As we are all aware, the Succession Amendment Act 2022 fundamentally changed the landscape of the estate of administration in Uganda. Among other reforms, the law introduced a fixed validity period for grants of probate and letters of administration which were subject to renewal. These reforms were aimed at curing a long-standing mischief, which was the tendency of some administrators and executors to obtain grants and hold onto estates indefinitely, without actually accounting, without distributing, and without regard to the rights of beneficiaries who are often widows, orphans, and dependents with nowhere else to run. So by operation of this law, thousands of old grants issued before the 31st day of May 2022 lapsed on 31st May 2025, and thereafter many applications for renewal extension of letters overwhelmed the division. The family division, as the main High Court division responsible for succession, became the center of these applications. The resulting influx on top of an already heavy caseload posed a real risk to timely access to justice in the family and succession matters. As judiciary management, we could not just stand by and watch. It was against this background that the first quarter special session for extension and renewal of letters of administration and probate was conceptualized and implemented, preceded by the orientation and training for the session judges to aid the resident judges at the family division to handle this influx. Today, we already did the review of the first session, and I want to begin by thanking those who contributed to its success. The 5 judges whose names were just mentioned there did a commendable job, and we heard that all the 5 together disposed of 1,433. And Justice Ketiruma just gave us the arithmetics about how much was unlocked. It is just mind-blowing. I don't want to repeat that. Some of them met the targets, but I'm thinking that most of them were really close to the target, because 250 something in just 3 weeks. I'm also aware that many of you started your court days. Some of them started as early as 7 a.m. in the morning. They sat for very long hours, stayed at court late in the night so that they could prepare and hand down those rulings. And all of you continued hearing matters even after the initial 3 weeks. And they did that without further facilitation, while self-facilitating yourselves and, of course, ensuring that the litigants actually received justice. That kind of dedication cannot be taken for granted. And on behalf of the judiciary and on my own behalf, I want to, and on behalf of the public, I want to say thank you. And thank you for that spirit of service. Allow me also to extend my deep appreciation to the head of the family division, the deputy head, and Honorable Justice Immaculate Businje, who behaved like true Africans. When your house is on fire, you just don't sit. You make an alarm, and neighbors, in the true African spirit, neighbors come and help you out, and that's what you did. So I want to thank you for that. That was exemplary leadership that made this special session possible, because you'd have chosen to just lament in the division and, continued. And so this approach was very good, and it sparked these sessions and laid the foundation for this success that we are celebrating today. I also want to thank the judges of the family division. You can from just their interventions, I am so confident that you, the judges who are going to participate in the second session, are going to be warmly welcomed. You can see the support. They're saying you can do this. We shall be in the boardroom to take you through this. So I want to thank the division judges. You've shared your experiences and you've really shown the other judges that they are welcome. I think it helps because we want to sustain this. Otherwise, if they get a bad experience, I don't think we would be having the second lot coming in. I also want to thank the Registrar High Court, yes, our worship, Prosi Katushabe, and the former registrar in charge of High Court Family Division, Sarah Tusime, who now I hear has been relocated to the Inspectorate of Courts, whose leadership was also at the center of the planning, day-to-day management of the special session. Your hard work made this extraordinary intervention possible. Thank you, Your Worships. I must also recognize the registrars at the Family Division who vacated their offices to create space for the session judges and found alternative places. I take this very seriously because I really love my space. For me to give my space out for more than a month, that was a real sacrifice. So I want to thank them for their willingness to inconvenience themselves for the greater good of the division. My appreciation also goes to the magistrates who greatly assisted the session judges, the secretaries who diligently typed grants of letters of administration. And, you know, it just goes down and down. When the judge is very busy, the secretary is very busy, the clerks are very busy, they're the ones who dig up the archives and records. And you had Justice Cecilia saying they always have reserve. If you cannot, proceed in all the 300, there are always reserves. So I want to thank those clerks and those ones who really dig up files from the archives, the long forgotten files. You can imagine doing that. I also want not to forget the ICT officers who facilitated ICMIS. Justice Businje said they are ready to take you through a training. So I want to thank them, and they must have been putting all the updates and resolving all the technical challenges. I also want to thank the process servers, the interpreters, the orderlies, the cleaners, the drivers, the bodyguards, and all those support staff who kept the daily machinery of justice running smoothly. I just want to put that into perspective so that we don't forget anyone, that success was actually and it was contributed by not just one person, but by all that group. And I want to thank each and every one of them. To the members of the public, the beneficiaries, the administrators, the executors, the advocates, other stakeholders who responded when called, they attended court when notified, and embraced this special session, we want to say we are grateful for that. A court system can only actually function when people whom we serve are willing to engage with it. Otherwise, we shall be talking to ourselves. Because of all these efforts, we can ably say that the first session made tangible impact, which all of you have already been alluding to. There are 1,433 applications for extension of letters of administration, the many families now that have clarity on their grants and can now proceed to finalize with the administration. So all those hanging families, you settled them. The patterns in the handling of these applications have begun to stabilize, leading to greater consistency and predict. I can just predict that the second one will even be more successful because we have learned from the first one, so we shall not make the same mistakes. Public confidence, of course, in the family division's capacity to respond to emerging demands has been strengthened. And although people keep filing these applications every other day, we as the judiciary have also kept managing the backlog in this category of cases to ensure that it's actually reduced. At the same time, our review must be honest about the challenges I hope that were encountered in the first one, and I think they were. from just the last bit of what I got. First, facilitation. The financial support provided for the special session was structured for only 3 weeks. The initial assumption was that this would actually be straightforward applications until reality set in. Many files proved far more complex than anticipated, involving large estates, numerous beneficiaries, and contested issues that required deeper inquiry and, in some cases, settlement discussions and even mediation. Some matters simply could not be rushed without compromising fairness or thoroughness. As a result, the session judges and their support staff worked well beyond the 3 weeks allocated period without additional facilitation. We recognize that the target of 300 files per judge within a short window was actually quite ambitious. I think we think about it now when we step back. I think it was really ambitious. 3 weeks, 300 per judge. In response to this challenge, we have extended the duration of the special session now to 30 working days to ensure that a more reasonable, yes, we need a clap for that, from 3 weeks to 30 working days. That could actually translate almost to 2 months. This is to ensure that a more reasonable and effective workflow is actually achieved. Otherwise, we shall just be ticking boxes. To the session judges of the first pilot special session, we appreciate your endurance and your candid feedback. It will help us do better in the second one. Another challenge was incomplete or defective files. A significant number of applications could not be concluded within the session timeframe because of the missing documents such as beneficiary consents, identification documents, or even because litigants raised issues that required mediation and further inquiry. These gaps led to multiple adjournments that slowed down the overall progress of the session. So as judges going for the second one, you could also maybe meet some of this, but I know that you'll be able to know how to navigate without grounding to a halt. You also faced the challenge of non-appearance of parties. A number of cases had to be adjourned, sometimes more than twice. Justice Celia has told us they don't dismiss. So in many instances, the judges actually rightly hesitated to dismiss such matters for fear of prejudicing the genuine beneficiaries. And I think this is a good thing, because then at the end of the day, what are you doing? You just want to offload and say you handled 300 applications, but what was the outcome of it? Was justice served? And finally, even as we celebrate the 1,433 files concluded, we note that there remains an enormous number of applications still pending before the division, with new applications being filed every other day. This caseload is dynamic. While we reduce one side of the backlog, fresh matters keep joining the queue. So Justice Keitirima and your family, of the family division, definitely when that happens, you always don't keep quiet, you'll always come, and we shall always be ready to actually jump in. Yes. These challenges are not lessons that should inform the design and management of the second session and subsequent interventions. This brings me to the second purpose of our gathering here today, which is training and orientation, and I think that was done beautifully. I don't need to go into it. I want to encourage you to see this as a place where judicial skills, empathy, and sense of justice can make some of the most meaningful contributions to society, and you will not be alone in this. The judges of the family division are ready to guide you. They have already shown that. As they did the first session judges, they will share the experience on recurring issues, how to approach applications, how to deal with obviously dormant estates, what are the red flags, and of course, how to strike a balance between firm enforcement of the law and putting a human face on every application. You will also have the support of the registrars at the family division, the magistrate, the support staff, who have now tested the complexity of these applications. And I urge you, as you begin the second session, my lords, be disciplined with time, start your sittings on time, manage adjournments strictly, and use each day meaningfully. But don't kill yourselves. We still need you. Work as a team with the staff assigned to you. Uphold the consistency and transparency. Remember that estate matters are closely watched by the public. They are watched by the bar. They are watched by everyone. So remain vigilant against fraud, but where genuine efforts to comply with the law are evident, do not overburden the families with technicalities. Please. Document your decisions clearly. They will form part of the emerging jurisprudence on post-amendment succession practice. To the registrars and administrative leadership, the first session has shown that specialized sessions do actually work, but they require sustained planning, adequate facilitation, and continuous coordination. So I don't want you to let down your guards. To the support staff, your role remains indispensable. We shall need you to continue helping the judges deliver on this. To the bar and the public, we shall rely on you heavily to prepare complete and compliant applications, to attend court when called, and to educate clients and communities about their obligations under the Succession Act. To the judiciary, for its part, remains committed to ensuring that these special sessions are not just one-off events, but part of a broader strategy to keep succession matters manageable. As I conclude, allow me once again to sincerely thank Justice Ketiruma and your team, to thank the session judges, the first session judges, who did exceptional work at the family division. And I want to thank also the registrars, the Registrar High Court, and the former Registrar Family Division, and the magistrates who gave support, and to the judges of the first session, and to the public, of course, for their cooperation. To the incoming judges, I welcome you to this important assignment. I trust that your training today, combined with the experience shared from the first session, will prepare you to carry the work forward with excellence. I want to thank you for listening to me. I say all this for God and my country.
Let's once again appreciate the Honorable Principal Judge for those remarks. My Lord, we appreciate, and this brings us to the close of today's meeting. We are going to have a review, group photograph, one group photograph, and we have tea, and departure is at leisure. And we wish all the best to the judges who are going to start on the sessions. And thank you so much, my lords, for being patient through the training. I'm sure that it is going to enrich your work at the family division. I also want to appreciate our trainer, Justice Kasibayo. I'm sure he has a wealth of experience. He can be reached in case of need, having been at the Administrator General and now with us. I'm sure there's a lot of support for us to keep this going. Thank you so much. My Lord, I'd want to call the high table so that we take one group photo, and then we can proceed for tea and departure at leisure. Please, let's come, your lordships and participants, your worships. Let's come. Justice Immaculate, come and take a seat here. Justice Kasibayo, who was our trainer, come and we have a seat here. Representative of the AG and the rest of the team, please, let's stand behind here and have one group photo as an accountability that we spent an afternoon here. My Lord, Justice Immaculate, my lords, can we come and stand behind, and when we have the photo? Okay, there are lordships that are still remaining. You can come. The photo has decided that they take the judges first. So, my lord, come and take your photo, and then the rest will join. Okay, the rest can join. My lords, you can stay. We'll join. You stay, we will join. Let's join this photograph, and then we close off. People would want to have their lordships in the photograph, so don't move away. Thank you so much. We can proceed and have a cup of tea.